Good afternoon, constitutional law students. This is a recorded lecture on religious freedom, which is covered in Module 12 this semester. In this lecture, I'm going to hit the highlights of Chapter 12 from your textbook and discuss some new information that is not covered in your textbook. Specifically, I will discuss the historical background of the Constitution's protection for religious liberty, what religion means, how the Supreme Court, Congress, and even state legislatures have protected the freedom to exercise religion. And last, how the Supreme Court has interpreted the Establishment Clause in a variety of different contexts. This lecture should not replace your reading of the textbook material. I'm not covering all of it in this lecture, so be sure you read the entire Chapter 12 from your textbook. But I'll begin now. Religious freedom in the 18th century. This is your historical background. Religion has always been a controversial issue. Even in the Declaration of Independence, you can see an effort to accommodate that controversy. It refers to both the laws of nature and nature's God. It recognizes that humanity is endowed by our Creator with certain unalienable rights. Thomas Jefferson and the men assisting in the effort were careful to use these inclusive references because they were well aware of religious pluralism that was rapidly developing in their new nation. And then, when the founders wrote the original Constitution, they included in Article 6 a prohibition. No religious test shall ever be required as a qualification to hold any office or public trust under the United States. In England, religious oaths were a requirement for holding office. These oaths included professions of belief in the tenets of the Church of England to the exclusion of Catholics and religious dissenters. And after the colonies established their independence and became states, most required religious oaths, holding over from their original charters from Great Britain. In other words, in order to hold public office in most state governments in the 18th century, you had to, at a minimum, profess a belief in a state-established church. In at least one state, Massachusetts, you had to be an elder in the Congregational Church to even run for office. But the founders of our nation clearly were opposed to such a requirement for national office, and so with little evidence of any dispute, they prohibited religious oaths for national office. During the ratification process, the people believed an even more specific protection for religious freedom was necessary. So two freedoms were added to the Bill of Rights in the First Amendment. The amendment provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Virginia led the charge on this amendment. Simultaneously with the ratification process, the state of Virginia was drafting a bill for religious liberty at the behest of James Madison and Thomas Jefferson. The primary goal of Virginia's bill was to eliminate the support of Virginia's dominant church with taxation. The common practice in most colonies, even after they became independent states, was that taxes would be used to support a state-established church. That is, citizens, no matter what they may believe, were required to pay for the operation of a state-established church. In Virginia, as members of dissenting churches complained about that coercion, Madison and Jefferson made eliminating state aid for churches their primary objective. These same two men wrote the First Amendment with Virginia's bill in mind. Most, though perhaps not all, of their colleagues in the First Congress believed that participation in religion should be a matter of choice, not coercion. In addition to this evolving desire for religious choice, there was a growing awareness that choosing a church to be the established Church of America was a practical impossibility. As I mentioned before, the Constitution was written during a time period when the Christian church was splintering into many different denominations. The founders lived in the midst of rapidly developing religious pluralism. There was no way to identify a single religion that all Americans would or should adopt. So now, having the First Amendment, let's look at exactly what it provides. Here again is the language. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That language gives us two protections. First, a protection or a prohibition on having an established church in America. The overriding principle of the clause is simply to prohibit the promotion of any particular religion, or even to promote religion over secularism. The second clause, the Free Exercise Clause, is a promise that Congress would not interfere with any person's free exercise of religion. The overriding principle here is to forbid the suppression of religious beliefs or practices. These protections are interpreted through different analyses, so we study them in the first instance separately. But as you'll soon see, the two protections sometimes interfere with one another. The cases you'll have read refer to this interference as the play in the joints between the Establishment Clause and the Free Exercise Clause. Sometimes maintaining a separation between church and state leads a state to an inadvertent suppression of religious exercise. You'll see examples of that in some of these cases. Before we go any further, we have to consider what religion is. What do we mean when we use the word religion? There is no single definition of religion. There is no official list of religions that are recognized by the U.S. Constitution. Even philosophical beliefs may be protected in the same way a religion might be. The Supreme Court has simply avoided having to define religion as it is used in the Constitution, and so we are left to guess what the limits of its meaning may be. We can surmise, however, that as has been the case when the court has interpreted the word religion as used in acts of Congress, the court will look for sincerity of belief. The Constitution's religious protections grew out of a recognition that individuals ought to be free to act on their conscience. So the court will consider whether, when asserting religious freedom, the individual is sincerely acting on conscience and not simply fabricating a religion just to avoid compliance with the law. Now let's move on to a study of the second of the two clauses, the free exercise of religion. An important distinction is to be made between belief and action. Government cannot dictate one's beliefs, but government can regulate conduct. The cases we study about the free exercise of religion involve government regulation of conduct that incidentally interferes with a person's religious practices. The case of Reynolds versus United States in 1879 is the very first time the free exercise of religion was addressed by the U.S. Supreme Court. And it reflects this distinction between belief and conduct. In religion, the Supreme Court upheld a federal law against polygamy, even when that law interfered with the practice of Mormonism. The anti-polygamy law applied generally to all people and had been part of the common law of England and most, if not all, Western European nations. The purpose of the law was to prevent the practice of polygamy, but the legislation did not target Mormons in particular. And in fact, the practice of polygamy was not an original tenet of the Mormon faith. But for a period of time, Mormons adopted the practice and considered it essential to their belief system. And yet, the Supreme Court upheld the anti-polygamy law in deference to Congress's determination that polygamy was harmful. Although Mormons were free to believe that polygamy was encouraged by God, they could not legally practice it in the United States. Over the years since the Reynolds decision, the Supreme Court's protection for religious practices has fluctuated. In 1963, the Supreme Court developed a test to evaluate the constitutionality of laws that interfere with religious conduct. This test came from the decision Sherbert versus Verner in 1963, and it is thus known as the Sherbert test. If a law poses a substantial burden on the exercise of religion, the government must show a compelling governmental interest that its law is narrowly tailored to accomplish and with the least restrictive way. The Sherbert case is set in Spartanburg, South Carolina, and it involved this woman pictured here. Her name is Adele Sherbert. She lived in Spartanburg, and she worked at a textile mill there in Spartanburg. She was fired for refusing to work on Saturday, which was her Sabbath. She was a member of the Seventh-day Adventist Church that recognized Saturday as the Sabbath and not Sunday. After being fired, Mrs. Sherbert applied for unemployment benefits from the South Carolina Employment Commission. But her application was denied because her unemployment was due to her choice not to work. She asked to be exempted from that rule, but was refused. Although the commission allowed exemptions for Sunday Sabbath observers, it would not allow exemptions for Saturday Sabbath observers. The Supreme Court invalidated the commission's ruling because it had no compelling reason to justify the denial of benefits for Saturday observance while granting them to Sunday observers. The commission's decision then smacked of discrimination that favored mainstream Christianity over less popular denominations of it. In 1990, SCOTUS meaning the Supreme Court of the United States, that's just a shorthand version of referring to it. In 1990, the Supreme Court appeared to draw back from the Sherbert test. In Employment Division versus Smith in 1990, the court applied lesser scrutiny to a state's refusal to grant unemployment benefits. The denial of benefits in the Smith case was based on the applicant's use of a controlled substance, peyote, in the practice of Native American religion. The men seeking unemployment benefits had been fired because they violated a generally applicable criminal law in the practice of their religion. So there was no evidence of discrimination. The criminal law against drug use applied to everyone the same, and that's what distinguished it from the decision of Sherbert. And the court instead applied the rational basis test. But the Smith case angered many people who contacted their representatives in Congress, and Congress took action. As a direct political reaction to the Smith decision, Congress enacted the Religious Freedom Restoration Act of 1993, through which Congress attempted to require states to satisfy the Sherbert test whenever their laws infringed on religious freedoms, even laws of general application like the one involved in the Smith case. But the Supreme Court invalidated the act, in part because Congress lacked the power under the 14th Amendment to enact it. However, the Religious Freedom Restoration Act still applies to Congress, so national laws that infringe on religious freedoms are still subject to the Act's stricter control on legislation. And many states have enacted their own version of the Religious Freedom Restoration Act, including South Carolina, so the test from Sherbert likely applies depending on what state you are in. A second effort by Congress to legislatively reverse the Smith decision is the Religious Land Use and Institutionalized Persons Act. Incarcerated Persons Act. The act imposes the Sherbert test to regulations on land use that substantially burden religious exercise and regulations that substantially burden religious exercise by prisoners. The Supreme Court has upheld this law, as it was enacted under a different source than the Religious Freedom Restoration Act. For this second act, the Congress relied on the spending and commerce clauses, not the 14th Amendment. So the court has upheld this second act without any invalidation of it. And it may seem now from these events I've described that the court and the various legislatures have been at odds on the subject of religious liberty. And perhaps that was true. But the present-day Supreme Court has extended greater protection to religious liberty in its most recent cases. Now let's look at the Establishment Clause. There are three theories that the court has applied to its interpretation of the Establishment Clause. The first is strict separation of church and state. Some Supreme Court justices adhered to this interpretive philosophy, but it didn't last long. If this theory controlled the interpretation of the Establishment Clause, many commonly accepted non-controversial practices would be swiftly ended. It may seem a laudable goal that is true to the founders' intent for the nation, but strict separation is not, from a practical perspective, an easy choice. Religious practices have pervaded our government institutions, from the reference to "In God We Trust" on our currency, to the invocation of God's blessing upon the Supreme Court at the opening of every session. And there's never been a sustained agreement among the justices of the Supreme Court that strict separation is actually required by the First Amendment. And so we have to proceed to our next option, neutrality. Under the neutrality theory, government must remain neutral toward religion, not promote any particular religion or even religion itself, as opposed to secularism. This may seem a viable option. There are several Supreme Court decisions in which the justices uphold a law because it is content neutral and otherwise rational. And so the neutrality rubric provides, if the law has a secular purpose, neither advancing nor inhibiting religion, and is narrowly tailored to accomplish that purpose with the least possible interference upon religious practice, then it would be valid. Some cases also consider whether enforcement of the law lends itself to excessive government entanglement in religious practices, perhaps through oversight of spending of state aid. But even the neutrality option does not always work. So we must have a third option, and that is the accommodation theory. Government may accommodate, the theory poses that government may accommodate the presence of religion even in some governmental activities. But government cannot coerce people into the exercise of religion. So presently, coercion seems to be the key point in the analysis. This theory can be seen in the most recent decisions of today's Supreme Court. In spite of having these three possible interpretive devices, as you might have noticed from reading Chapter 12 of your textbook, it is difficult to predict how the court will rule in any given Establishment Clause case. The precedents are messy and inconsistent. So we'll now look at how the Supreme Court has interpreted the Establishment Clause in a variety of different contexts, starting with religious displays, religious symbols. Unfortunately, there's no test that leads to consistent results in cases involving religious monuments. Justice Breyer's concurring opinion in Van Orden versus Perry offers a good summary of the dilemma, and it is excerpted in your textbook on pages 351 through 352. If you read what Justice Breyer has to say, and then read all the cases about religious displays, you're going to come to the realization that the court decides the issue of religious displays on a very case-by-case, content-specific analysis. As Justice Breyer acknowledged, he's not applying any test. He is simply applying his legal judgment based upon the underlying purposes of the two religious freedom clauses read together. Here are some photographs of the monuments from 3 of those cases. In County of Allegheny versus ACLU from 1989, the court was presented with this nativity scene. It stood alone on the grand staircase of the courthouse with the banner Gloria in Excelsis Deo hanging by it. A majority of the justices held that this display was impermissible due to its context, where it was centrally placed in the courthouse and proclaimed religious adoration of a deity. The creche belonged to a Catholic organization who got permission from the city to display inside the courthouse. In the same case, the court had to look at this menorah. It's 18 feet tall, and it stood next to a 45-foot Christmas tree outside an adjacent building. A majority of justices believed that the menorah was permissible. Overall, the display referenced 2 different traditions for celebrating the winter season, and underneath the tree, you can sort of see it in the picture, there's a sign that reads, "Salute to Liberty." A Jewish organization owned this menorah, and the city set it out each year. The next case that I'm going to show you a picture of is Van Orden versus Perry, the one I mentioned just a second ago, where Justice Breyer explains the complicated nature of these types of cases. In Van Orden versus Perry, the court had to consider this 6-foot-tall monument of the 10 Commandments that was displayed among 16 other monuments and 21 historical markers on a large park surrounding the Texas Capitol. A majority of the justices believed that this was permissible, again due to its context. The monument was part of a larger, diverse display of symbols that relate to the legal and political history of the state. It was donated by a civic group and had rested on the grounds of the Texas Capitol for over 30 years. And the last one I have to show you is from a case that is not in your textbook, American Legion versus American Humanist Association from 2019. This case involved the constitutionality of a very large cross located near a highway. The group that challenged this display wanted the cross to be removed, as it is obviously a religious symbol standing alone on government property, a memorial park. The cross was huge and heavy. It was erected in 1921 to honor World War I veterans. And in this case, the court upheld the display as permissible for a variety of reasons, but among them was the fact that the cross had been on display for nearly 100 years. The court didn't want to set a precedent by which governments would begin taking down religious displays all over the country that had been present for a long time and become part of the community's history. So you can see a bit of the unpredictability that exists in religious monument cases. Although I've shown you photographs of some of these displays, their appearance is not the determinative factor. Religious display cases turn on a variety of factors and depend to a large extent simply upon the independent judgment of whomever the justices happen to be when a case is presented to the Supreme Court. Now we're going to look at religion in the classroom. Schools are a tricky situation, and that's because the students, children, are very impressionable. Although schools have a responsibility to shape children into responsible adults, so do their parents. And parents may have different beliefs. They may not be Christians, and they may not want their child being taught by school teachers to adopt Christian beliefs or practices. In the mid-1900s, the Supreme Court was asked to consider to what extent Christianity can be practiced in public schools. Engel versus Vitale from 1962 is the first time the court had that opportunity. New York had a law that required teachers to begin the school day by leading a prayer written by school employees that invoked the help of Almighty God. Students were not required to participate in the prayer, and the prayer was neutral toward the various traditions within Christianity. But that was not enough. The Supreme Court struck down the law because school employees wrote it, school teachers led students in a recitation of it, and children can still feel pressured or coerced into participation due to their developmental stage in life, wanting to please teachers, wanting to fit in with their peers, wanting to go along with the crowd. To expect children to have the courage to voluntarily stand against the tide in that situation is to deny reality. School District versus Shemp from 1963 came in just a year later, and the court is addressing another common practice, Bible reading. In that case, the Shemp case, each day began with the teacher reading from the King James Version of the Bible to her students, and then leading them in a recitation of the Lord's Prayer. Again, students were not required to participate and could leave the room as it occurred, but two families objected because if their children chose not to participate, they would receive negative attention and were likely to be socially shamed by their peers. And the Supreme Court agreed that the practice violated the Constitution because even though the school did not compose the prayer, teachers were doing the reading, teachers were leading the recitation of the prayer. And there is an implicit pressure on young people to participate in those situations. Later cases continued to strike down similar practices. Moments of silence, moments of meditation or voluntary prayer being held at the beginning of a school day is an example of one that was struck down. Student-led prayer before an entire crowd over the loudspeaker before a football game was struck down. Prayers by community clergy whose content was regulated by the school administration at graduations. There also, the practice was held as a violation of the Religious Freedom Clause, the Establishment Clause. However, recently, in 2002, the Supreme Court has begun to go a different direction. In Kennedy versus Bremerton School District, a Washington school fired its part-time high school football coach because he refused to stop praying on the 50-yard line at the end of a game. Many, as you can see depicted in the photo, of the football players joined him, and later so did spectators. The prayer was never required of anyone, including the players. But the school asked the coach to stop leading the prayer because it feared that allowing the praying to continue would violate the court's long-running precedents that had prohibited school employees from leading students in prayer. But the coach challenged the school's decision because he claimed it violated his free exercise right. The Supreme Court agreed and struck down the school's policy. They held that school prayer in this circumstance did not violate the Establishment Clause, seeing no evidence of coercion, and recognizing that denying the coach his individual freedom to pray violated the Free Exercise Clause. So notice here, the facts of this case implicate both clauses at the same time. The case begins with an individual who is personally and sincerely religious, seeking to freely exercise his faith in a public setting. He happens to be a school employee and therefore a state actor bound by the First Amendment. When he acts, it is as if the state is acting. And so he cannot coerce students to join him. Whether those football players felt subtly pressured to pray with their coach may be impossible to truly know, but the Supreme Court has decided that government cannot interfere with an individual's religious exercise simply out of a desire to avoid violating the Establishment Clause. A state may seek to impose greater protection against state endorsement of religion, but it cannot do so in a way that interferes with the equally important principle of individual freedom to practice religion. The textbook makes a good final point about this issue on page 354. The Supreme Court has never said that it is unconstitutional for students to pray at school. There has never been a ban on prayer in schools. That is an exaggeration generated by individuals who disagreed with the court's decisions. Students can, of course, pray in school. They can read the Bible or any religious text in school. The point is that schools, like all government institutions, simply cannot coerce students to do so. Next, we'll talk about state aid to religious institutions. Recall my discussion of James Madison and Thomas Jefferson's effort to eliminate state aid to Virginia's dominant church. The very first effort, then, to officially separate church from state in our nation was actually an effort to avoid making taxpayers financially support religious institutions. And yet, we have a host of Supreme Court decisions demonstrating various tolerances for that very thing. It can seem confusing and inconsistent, but let's try to parse it out. The first case is the first case to even ever address the Establishment Clause was a case involving state aid for a religious hospital. Bradfield versus Roberts, 1899, addressed a grant to a Catholic hospital to build a ward for the treatment of indigent patients. The Supreme Court upheld the grant because the money was being used for a secular purpose, and that secular purpose became part of the test applied by the court for the Establishment Clause going forward. A very similar but far more recent case that was decided after the publication of your textbook is Trinity Lutheran versus Comer. In Comer, the court considered Missouri's granting program that encouraged the use of environmentally sustainable playground surfaces. Missouri had a no aid provision in its constitution, which was an effort to uphold a strict separation of church and state. When Trinity Lutheran applied for the grant money to renovate its daycare playground, the church was denied. Missouri's effort to uphold the separation of church and state fell into that play in the joints of the two religion clauses. By excluding religious institutions from the program, the state discriminated against religious institutions and thereby violated the Free Exercise Clause. By excluding religious institutions from the program, the state discriminated against religious institutions and thereby violated the Free Exercise Clause. So the rule we get from these decisions is this. Once a state develops a financial aid program, it cannot exclude individuals or organizations from participating in it simply because of their religious status. A little more on state aid. Next, consider situations when government funding, instead of going directly into the pockets of religious organizations, is paid first to parents or students who then choose to apply the funding toward religious education. In Everson versus Board of Education in 1947, the Supreme Court upheld a law that provided financial assistance to parents for transporting their children to school, even where some of the schools the kids attended were parochial or religious. And that's because the program, applied generally. All parents within the city received the support. Funds were provided to parents for the benefit of their children, not the schools. And the law had a secular purpose to provide a safe transportation to school in a community that had no schools available. The majority also addressed the interplay of the Establishment Clause and the Free Exercise Clause. If financial aid were denied to parents sending children to parochial schools, then the law would be discriminatory and unjust under the Free Exercise Clause. A case similar to Everson is the Zellman versus Simmons-Harris decision of 2002. It's described in your textbook, where the state of Ohio's state aid program was upheld because, again, the program was enacted for a secular purpose. The state aid was given first to parents, who then chose to apply the funds to religious schools. So it seems that the indirect way funding is received by religious organizations plays a large role in the court's finding that the Establishment Clause is not violated. The Everson and Zellman decisions are very similar to a most recent case, Carson versus Macon from 2022. In Carson, the court addressed Maine's tuition assistance program. Several school districts in Maine did not have schools providing secondary education, which is middle and high school. So Maine developed a program whereby it would cover the tuition costs of students who attended private schools for their secondary education. But religious private schools were not allowed to receive that tuition assistance because Maine believed government aid given to religious schools would violate the Establishment Clause. The Supreme Court said Maine's policy violated the Free Exercise Clause. Again, once Maine chose to provide a tuition assistance program, it could not refuse that assistance to schools simply because of their religious status. The last topic I want to mention to you is what I jokingly call the forgotten lemon. Your textbook mentions an important decision of the Supreme Court involving state aid to religious schools, Lemon versus Kurtzman from 1971. In Lemon versus Kurtzman, the court tried to establish an interpretive test once for all for the Establishment Clause cases, and it became known as the Lemon Test. The test goes like this. Does the law have a secular legislative purpose? Does the primary effect of the law neither advance nor inhibit religion? And finally, does the execution of the law require excessive government entanglement with religious institutions? Now, while a laudable effort to create some consistency in the interpretation of the Establishment Clause, the Lemon Test did not always work and did not always truly seem applicable. Finally, in 2002, with the Coach Kennedy decision I referenced a moment ago, the court recognized that the Lemon Test was no longer valid precedent, so do not look for it to be applied in any of the cases going forward. That's all I have for my lecture on religious liberty. Again, please do not use this lecture as a substitute for reading the textbook. I have not covered everything in it. I've merely hit the highlights. I just wanted to give some additional background on these issues and update you on the case law, some of the more recent decisions the Supreme Court has released after the publication of the textbook. If you have any questions from reading from what the textbook says or from this lecture, please do not hesitate to call or email me or stop by. You guys have a great day.